Hi everyone, this is CA Harsha Buddala. Today we are going to discuss a recent Supreme Court judgment, that is DGGI versus Gameskraft Technologies Private Limited Supreme Court judgment on online money gaming. Okay, now before proceeding into this judgment, I will just give you a brief about the GST issue involved in this online money gaming. Okay, now like the issue involved was there are two timelines, especially that is before 1st October 2023 and after 1st October 2023. Now why I have divided the issue into two timelines, that is before 1st October 2023 and after 1st October 2023, was there were a lot of amendments came with effect from 1st October 2023. Like Rule 31B, Rule 31C was introduced, and there was an amendment made to Entry 6 of Schedule 3, and also a new definition like online money gaming, specified actionable claim, online gaming. All these definitions and all these rules were introduced in the CGST Acts and Rules with effect from 1st October 2023. That is the reason why this entire issue can be briefly divided as after 1st October 2023 amendments and before 1st October 2023 amendments. Now coming to the current case, the Supreme Court case, it is all about the period before 1st October 2023. Because after 1st October 2023, that is after when Rule 31B, Rule 31C was introduced, no, there was no any ambiguity, and whatever the rule has been prescribed, that is, see, I can simply say that the Rule 31B had said that for online money games, whatever the deposits the player is making, say for example Rummy Circle game is there, like, or else Dream 11, no, fantasy games are there. Now in these games generally players will make some deposit. Now what Rule 31B is saying that on that entire deposit GST should have to be paid. For example, a player had deposited 1000 rupees in his wallet, so on that 1000 rupees deposit GST has to be paid, is what Rule 31B is saying. And this is, and the rule itself was introduced with effect from 1st October 2023. Thereby the gaming companies had started complying this, and there was no any ambiguity. Now the ambiguity or dispute is with regard to the period before 1st October 2023. Now what the dispute was, I mean to say that what actually used to happen before 1st October 2023 was, say for example a player is playing Rummy Circle game. He had deposited 100 rupees in his wallet. Now what the gaming companies used to do was, in that 100, let us assume 10 rupees is the platform fee. So what they will do now, from that 100 rupees they will retain 10 rupees. The exact wordings or the proper wording should be, they will retain that 10 rupees, and the balance 90 rupees they will put it in the pool. Okay, so that pool will be used to award or prize the winner. That is how they used to work. And coming to the GST aspect, the gaming companies are of the view that, or their contention was that, we are providing a mere platform services, thereby our GST applicability or the value of our supply is confined strictly only to the platform fees, thereby we will pay GST only on the 10 rupees. This is what the contention of the gaming companies. To put it in a more simple way, after 1st October 2023, there was no dispute. They have started paying GST on the entire amount. The dispute was with the before period. Okay, before period, the gaming company's contention was, we are supposed to pay GST only on the platform fee. Now why they have came to this contention was, to understand that we have to go and see what Rule 31A is saying. Now Rule 31A 3 especially, what it is saying thus, the value of supply of actionable claims in the form of chance to win in betting, gambling. Now if you observe, the word they used here was chance to win. Now gamings are of generally two types. Game of skill and game of chance. Skill and chance. Now the gaming companies' contention was, whatever the Rummy Circle game and whatever the Dream 11 fantasy games all are there, all those games are game of skill, which involves a predominant amount of skill or a substantial amount of skill. So whatever the rule 31A is saying, so this rule 31A is saying, before introduction of rule 31B, rule 31C also, rule 31 is saying that 100% of the face value you have to pay the tax. But they use the word here chance to win. Thereby, gaming companies had taken a view that our games like Rummy Circle and Dream 11 are game of skills. Thereby, we need not to follow this. This is what the view of the gaming companies. This was disputed by the department, and department had said that no, even though it is a game of skill, you have to follow rule 31A3 and you have to pay GST on the entire amount deposited. Now your GST should not be confined only to the platform fee. This was the dispute thing. This was the dispute actually happening between the gaming companies and the department. I hope I am clear up to here. Now, so based on this was the issue, and what happened was the gaming companies was issued show cause notices by the GST department with a huge demand. Like the entire deposits made by the players they have considered, and on that they have applied the GST rate, and they have demanded tax along with interest and penalty, which run into a huge demands. Now what the gaming companies had done was, the gaming companies are of the view that no, the rule 31A3 is applicable for games of chance only. Ours is a game of skill, thereby we need not to follow that. However, after 1st October 2023, anywhere rule 31B is very clear. Irrespective of whether it is game of skill or game of chance, you have to pay GST on the entire deposits. It was deposit in rule 31B, it was the stake or the bet amount in rule 31A. This was the wordings. Now this was the difference of interpretations between the gaming companies and the department. Now once the show cause notice was issued, the show cause notice was challenged before the Honorable Karnataka High Court and some other High Court also. Now in this before the Honorable High Court, what was the contention of the gaming companies was same. Our games are all already, and importantly one fact was, there were a settled jurisprudence or precedents is there stating that the Rummy Circle game or Dream 11 games are of game of skill. It was settled thing. So thereby this was properly contested by the gaming companies before the Honorable Karnataka High Court, and Karnataka High Court had accepted the contention of the gaming companies and said that yes, yours is a game of skill. Okay, thereby no, you need not to pay GST on the entire amount, and they have quashed the show cause notices issued. Karnataka High Court had quashed the show cause notices issued by the department. Challenging this, the department had approached the Honorable Supreme Court. This was the brief about the issue involved. Okay, now before proceeding into this Supreme Court analysis, I just want to quickly highlight some important things. That, see, if you observe rule 31B and rule 31C, one second. Okay. So rule 31B and rule 31C had 31B especially doesn't made any difference whether it is an game of skill or game of chance. But if you see the wordings here, see, before going into the Supreme Court analysis, I just want to quickly give a clarification. For that I am taking into a different aspect, not a completely different aspect, but to the Schedule 3. See, we all know that if anything is mentioned in Schedule 3, it is neither a supply of goods nor supply of services, thereby GST cannot be attracted. Now, see, this betting, gamblings and all are all called as actionable claims. Now, Schedule 3 of GST, there was an entry called Entry 6. What Entry 6 is saying was, actionable claim other than lottery, betting and gambling. So what it was saying was all actionable claims are getting covered under Schedule 3, but in Schedule 3 what was excluded was betting and gambling. Lottery, betting and gambling was excluded from Schedule 3. In fact, I would have to start with, if you ask me to start with the very basic point, no actionable claim. The definition of goods in GST also includes actionable claim. So whenever a gaming company, what the department is saying that you as a gaming company is supplying an actionable claim. For example, I have played Rummy Circle game. Now I have won it. I have won the game. Now I can demand some amount from you. So actionable claim in simple words means an unsecured debt with legal enforceability. Now after I winning the game, gaming company is supposed to pay me some amount which I can legally enforce. Thereby it is an actionable claim. But importantly, actionable claim is excluded or it is included in Schedule 3. Thereby on actionable claims GST will not be applicable. But actionable claim, but Schedule 3 excludes betting and gambling. So now think in the gaming company point of view. What the gaming company will try to contest before the Honorable Supreme Court that see when my game or whatever the games or whatever the services which I am providing, when it would be taxable as an actionable claim. The moment it is an betting and gambling, then only it will be taxable. See, if it is not betting and gambling, if it is an ordinary actionable claim, I will get a protection under entry 6 of Schedule 3. Now, actually speaking, this entry was later changed as actionable claim other than specified actionable claims. So, this other than specified actionable claims and all wordings came after 1st October 2023. Anyway, so I'll just once again brief what the gaming companies try to contend was. See, I have to prove that my whatever the games I am providing through my platform, that is Dream 11 or Rummy Circle, is not betting and gambling. The moment I am successful in proving that my game is not betting and gambling, okay, I will fall under Schedule 3. The moment I fall under Schedule 3, there will not be any GST. This is what the gaming companies had tried to present or tried to prove before the Honorable Supreme Court. Okay, I hope I am clear up to here. Now, for that what they have done was they have relied on one Supreme Court judgment or a number of Supreme Court judgments. In that two important Supreme Court judgments were RMDC 1 and RMDC 2. These are the two important Supreme Court judgment. Even in fact, if you refer the judgment copy, it was a 400-page huge judgment. This DGGI versus Gameskraft Technologies Private Limited. In that, majority of the time the Supreme Court had spent on analyzing RMDC 1 and RMDC 2 case. So this is what the importance of RMDC 1 and RMDC 2 case in this importance of these cases in the current case. Now what was this RMDC 1 case and what was this RMDC 2 case, that we have to understand. Okay. Now before that I just want to highlight two constitutional entries which are very much relevant in understanding this RMDC 1 and RMDC 2 case. That is entry 34 of state list and entry 62 of state list. Now if you observe the entry 34, that is betting and gambling, and also entry 62, if you observe, taxes on bettings and gambling, taxes on betting and gambling. These are the two relevant entries, and mind it, these are there in state list. These are there in state list, and importantly I am talking about pre or before GST, that is before 101st Constitution Amendment. This is the position. See, even after 101st Constitution Amendment, there was no any change in entry 34, but in entry 62 there was a change. Now if you observe the post amendment, the entry looks like this: taxes on entertainments and amusements to the extent levied and collected by Panchayat. See, if you observe, you couldn't find the word taxes on bettings and gambling. Why and all I will discuss in a couple of minutes, or in a subsequent discussion I will clarify that. Okay, but these two entries are important, and even more important was these two entries were under state list. If anything was there in state list, the legislative competence or the power to make legislations or the power to regulate these subject matters is strictly with the state legislatures. Now betting and gambling is there in state list. It means that the state legislatures had the competence to regulate them or to make legislations. Okay, this basic we have to be very clear. Now RMDC 1. RMDC 1 case, what is this RMDC 1? Now RMDC is a name of a gentleman called RMD Chamar Bagwala. So there are two cases. One case we are referring as RMDC 1 and the other case we are referring it as RMDC 2. Now this RMDC cases may what is relevant was entry 34 and entry 62 of state list are, or I mean to say that in RMDC 1 case they have analyzed a particular legislation called Bombay Lottery and Prize Competition Control and Tax Act. So this legislation was passed in the Bombay province, and the power the power to the legislature to pass a legislation of Bombay Lottery and Prize Competition Control and Tax Act came from entry 64, and to levy the tax it came from entry 62. See, state list or in union list mein what will happen na? Normal entry will be there and also taxation entry will be there. Entry 34 is talking about gaming, betting and gambling, and entry 62 is talking about taxes on betting and gambling. Okay, see why we are referring all these things and all, you will get clarity in a couple of minutes. Now RMDC 1 mein what happened was, this person RMD Chamar Bagwala, he had a newspaper. He had a newspaper called the Sporting Star. Now this paper is printed and published in Bangalore, and it contains a crossword puzzle competition called the RMDC Crosswords, for which entries are received from various parts of India. Now what this person used to do was, he used to conduct a prize competition in his newspaper called Sporting Star. That competition is called RMDC Crossword Puzzles. Now his contention was, my RMDC prize word puzzle is a competition or is a kind of game of skill. Now the Bombay Lottery and Prize Competition Control and Tax Act is putting tax on his crossword puzzle also. Now what he is trying to prove before the Honorable Supreme Court was that my crossword puzzles are game of skill. The moment it is a game of skill, it cannot be called as betting and gambling. It cannot be called as betting and gambling. Thereby this Bombay Lottery and Prize Competition Control and Tax Act cannot put tax on my crossword puzzles, is what his contention was. Now the Supreme Court had analyzed this issue, and Supreme Court had categorically said in RMDC 1 that betting and gambling doesn't include game of skill. It had categorically said that. In fact, they even said that this Bombay Lottery and Prize Competition Control and Tax Act put a tax only on game of chance. This act or this legislation doesn't have any intention to put a tax on games of skill. But this RMDC Chamar Bagwala, his crossword puzzles, what the scheme was, already for that crossword puzzle an answer will be decided by the promoter of the newspaper, and that answer, whoever guessed the answer properly, so that person will be the winner. So the Supreme Court had said that this game is of more of guessing the correct answer. Thereby this game we will consider it as game of chance, and the moment it is a game of chance, it will be getting covered under the term called betting and gambling. As it is a betting and gambling, the Bombay Lottery and Prize Competition Control and Tax Act, which is taking power from entry 34, has competent enough to put a tax on your crossword puzzles. I will simplify it once again for the purpose of even more better understanding. In the RMDC 1 case, what was concluded was, entry 34 mein the wordings they used was betting and gambling, betting and gambling. See, I am making a law by using this entry. Okay, so whenever I am using this entry and I am preparing a law, it means through that law I can control only betting and gambling. Okay, now what is meant by betting and gambling? So betting and gambling means it is considering the bets put on the games of chances. In other words, I can say that the betting and gambling words doesn't cover game of skill. This is what the Supreme Court had said in RMDC 1. Now, the petitioners in our current case, that is a DGGI versus Gamecraft Technologies Private Limited, in this case, the gaming companies had placed a heavy reliance on this case called RMDC 1, because in RMDC 1 already the terminology called gaming and skill was interpreted. So they have said that gaming and more importantly, the taxing power which is coming from entry 62 is also using the same word called betting and gambling. It means a taxing on betting and gambling. Me being a state legislation or state assembly has a power to put a tax. Now I can put a tax only on betting and gambling, not on everything. Through this entry 62, I can put a tax only on betting and gambling. Now in that betting and gambling, game of skill will not be included. This is what the outcome of RMDC 1. Now you can get a doubt that, so rightly up to here I hope I am clear, and rightly the gaming companies had placed reliance on the RMDC 1 case. But one doubt what we can come was, in GST what is the relevance of this entry 62? Because this entry 62 had become like this now, and there were no any word called betting and gambling. You have to remember that why this entry 62 was amended. It was amended because of the 101st Constitution Amendment. Now why the 101st Constitution Amendment had removed the word betting and gambling here? Because the 101st Constitution Amendment, through 101st Constitution Amendment, GST had came into force, and GST had subsumed the taxation power given in entry 62. Thereby, whatever the interpretation that Supreme Court had done in RMDC 1 case, because in RMDC 1 case they have analyzed entry 62 and entry 34 now. So thereby, whatever the GST I want to levy on the online money gamings, it all had subsumed the power which was already there in entry 62. Thereby, the terminology of betting and gambling used in the RMDC 1 judgment is relevant for me because it had subsumed entry 62. It simply speaking, this entry 62 is now with GST, with the both the parliament and with both the state legislatures. By using this only, we are putting tax on the online money games. Thereby, the betting and gambling ka definition what was given by the Supreme Court in the case of RMDC 1 and RMDC 2 is relevant. Okay. Now, up to here, I think I am clear. Now, coming to another important judgment, that is RMDC 2. So, RMDC 2 won't take much time. I will just close it very quickly. It consists of only 3 points. Now there was a central legislation, a parliament legislation called Price Competitions Act 1955. Now you can, a doubt can rise in your mind that you just now said that entry 34 and entry 62 was in state list. How can again a central or a parliament legislation had came into picture? There was an article called Article 252 of the Constitution of India. As per this article, even though some some power is with the state government, like betting and gambling, the power is with the state government. If some states had requested the parliament to make a law, then parliament can make a law by using this Article 252. So by using this, at that time some states had requested the parliament to make a law on betting and gambling. So under Article 252, the parliament had made this Price Competitions Act 1955. It is a it was a central law, that is a parliament law. Now what happened in this Price Competitions Act 1955 was, there was a section called section 2 clause D. In this section 2 clause D total ban on all prize competitions was kept. Whether it is a game of skill or whether it is a game of chance, tax was kept on all, or ban was kept on all the games, irrespective of fact whether it is a game of skill or game of chance. Now the learned counsel, the legendary advocate Nani Palkiwala sir had argued this case on behalf of the RMDC. So what he had put before the Honorable Supreme Court was that, see, if you are putting ban, see, there was a through entry 34 I can regulate the gamings. Regulating the gamings means I can put ban also. Okay, ban as well as tax also will come. Okay, anyway, now what the argument put forth by the learned counsel before the Honorable Supreme Court was that, see, this section is putting ban on all types of prize competitions including game of skill. Now there was a precedent which says that game of skill cannot fall under entry 34 and entry 62. I am completely outside of it. Now whatever the legislation you are referring, it is putting ban on all the games, which is not correct. Okay, see, putting ban on game of skills by using this entry will itself make the entire legislation or the entire section invalid. Okay, so you had the power only to control game of chances, but you are overriding it and you are trying to regulate and trying to ban even the game of skills. So thereby the section itself is not valid, is what the argument put forth before the Honorable Supreme Court, and Supreme Court had also agreed. But the council on behalf of the revenue had requested that, see, one more point what the learned counsel on behalf of the petitioner or on behalf of RMDC had submitted that, see, if you are putting ban on game of skill, it is nothing but you are what to say, that you are breaching my fundamental right given under Article 19(1)(g). Okay, so you are violating my fundamental right, as you are, because right to business or right to do some practice of profession and business is my fundamental right, that you are putting a ban, thereby I can challenge your legislation. Now the council on behalf of the revenue had requested the Supreme Court to apply doctrine of severability. So even though the section is covering all the kinds of games, you please apply the doctrine of severability and separate the game of skills. So in this judgment, what happened was, ultimately they have said that only game of chance only will cover, game of skill will not be covered. So this is all about RMDC 1 and RMDC 2. Now by this what we can understand was, in RMDC 1 and RMDC 2 already the terminology betting and gambling was analyzed, and they have clearly said that, categorically said that, these entry 34 and entry 62, which was entry 62 especially the taxing entry, which was later subsumed by the GST, it means that whatever the analogy or whatever the interpretation we have done for the betting and gambling in RMDC 1 and RMDC 2 will be applicable to the GST also, as it had subsumed the relevant entries. Now the gaming company had rightly contested before the Supreme Court. This is what we can say up to here. But Supreme Court had taken a different view. So the jurisprudence which was settled 60-70 years back had reversed here. In fact, I won't say completely reversed, but there was a separate aspect which the Supreme Court had analyzed. What the Supreme Court had said was, this is a very important paragraph which of this judgment, especially in the context of analyzing the RMDC. The first question that requires to be asked is whether the facts of RMDC 1, any game of skill was played with stakes. Any game of skill was played with stakes? No. The answer to this question is a overwhelming no. Now, when in facts of RMDC 1 there was no elements of staking on a game of player or participant, the judgment in RMDC 1 cannot be a binding precedent. What the Supreme Court had analyzing here, na? See, gaming, you are classifying it as skill and chance. Okay, I agree with that. In RMDC, what it was said, only chance is getting covered, skill is outside. But what Supreme Court had said that on any game of skill in RMDC, did we analyze it as that it was the same Supreme Court? The Supreme Court had asked, did we analyze any scenario of on game of skill, someone is putting stakes, someone is putting betting. We didn't analyze that aspect. Whether betting and gambling includes a game of skill also. We said no. But there was no any discussion whether or the scenario of there was a game of skill playing, but the player or any third party is putting bet on that outcome of the game of skill. Whether this scenario did we covered in RMDC 1 is what the question put forth before the Supreme Court. The answer is no. Thereby the Supreme Court is saying that then RMDC 1 and RMDC 2 doesn't have any precedent or a binding precedent in this current scenario. So here what Supreme Court is saying was, I agree. See, current up to here what was the settled principle was game of skill completely outside the ambit of betting and gambling. Game of chance, it is getting covered. Now what Supreme Court is saying was, now I will not game of chance anyway it is betting and gambling. Game of skill I will check in another scenario whether on that game of skill any stakes or any bets are going on now. If the answer is yes, then it is also a gambling only. So a game of skill, on game of skill, again some betting and all should not happen. Now in Rummy Circle what happening? Of course the card games which they are playing, that is game of skill only. That was a settled thing. The Supreme Court had also didn't disputed here. That is a game of skill. But on that betting is happening now. On that betting is happening. Even though it is a game of skill, on that betting is happening. Thereby, it is also called as betting and gambling. You can't take the shelter of RMDC 1 and RMDC 2 is what the Supreme Court had said. Okay, I hope I am clear up to here. Now, so there was another important point which the Supreme Court had said was, in game of chance and game of skill, see generally game of skill is there. On that, to play that game of skill I have paid some entry fee, and that entry fee is only for participation. For example, there was a game of skill happening, like a chess competition is happening. To participate in the chess competition I have paid some entry fee. Now this entry fee, why I am paying? This entry fee I am paying to reserve my right to participate in the game. But in the current Rummy Circles and all what I am doing, I am also paying there some entry fee. But that entry fees or the deposits what I am doing is forming part of the pool or the stake which they are using to prize the ultimate winner. Yes or no? So yes, this is what actually happening. So what Supreme Court had said was, see the entry fee if you are paying merely for participating, then also I don't have any problem. Now the entry fee which you are paying and it is forming part of the pool or it is a stake or the bet which you are putting, then I have a problem and I will consider it as a game of chance, or in other words it will also be called as betting and gambling. Okay now, so I hope I am clear here. Up to here I am clear. So, or else I can quickly give an summary like thing like game of chance, whether I am paying entry fee, whether I am paying whether along with entry fee I am putting bets and all, or whether that entry fee is forming part of the stake and all, that doesn't matter. Game of chance is always betting and gambling. Game of skill, if I am paying only entry fee for mere participation in the game, then it is not betting and gambling. I am paying fee, see whatever it may be. See why they use this entry fee and all analyze and the moment Supreme Court had said this, the gaming companies had tried to contend before the Supreme Court that we are also collecting only mere entry fee. Then Supreme Court rejected that because your entry, whatever they said that whatever the amount we are collecting is also an entry fee. I correct myself, what they have said was whatever the amount we are also collecting is also like an entry fee. No, the Supreme Court had that no, the entry fee what you are collecting is becoming, or it is forming part of that pool or stake. So and that stake is going to like it, see again another important point which we have to consider was here the betting is happening on an uncertain future event, whether that particular person will win or not, or that particular event will happen or not. It is an uncertain thing. On that uncertain thing we are putting some betting and all. Of course it may involve some certain amount of skill, but that doesn't matter. Simply speaking, Supreme Court had said that that entry fee what you are paying, if it is forming part of that pool or stake, then I won't consider it as game. Even though it is a game of skill, I will consider it as betting and gambling. Okay, so I hope I am clear up to here. So this is how the Supreme Court had said that the even though the games which were game of skill, it is betting and gambling only. See, the moment you are called your game is betting and gambling, you are not outside the entry, you are not outside the schedule 3. Okay, it means you are making a supply. Okay, now the other important issue which was analyzed by the Honorable Supreme Court was, see what the rule 31B is saying, you have to pay tax on the entire deposit. Now the other contention made by the petitioners was, see we are retaining only platform fee, the entire amount we are not carrying, we are only retaining platform fee, and the price pool is maintained separately in an escrow account. Now 100 rupees what they are depositing, we will take only 10 rupees, and that remaining amount we are keeping it in a separate account, in an escrow account. How are you attributing it as my consideration? In GST what their contention was, you have to put tax on my consideration. You have to put tax on my consideration. Your consideration will become the your transaction value will become the your value of supply, and you have to put tax only on my value of supply. So you are contending that the entire deposit, no, I am confining only to platform fee, and the after deducting the platform fee I am putting the amount in a separate escrow, and also I have never appropriated as my consideration, and I am holding it in a fiduciary capacity as a trustee. I am holding it, and also segregated amount would not form of my liquidation asset. Actually what happened was, one of the learned counsel on behalf of one petitioner had submitted that, see even as per insolvency bankruptcy code, if you think, if any gaming company go into liquidation and this corporate CIRP process had started, these deposits of the players are not being considered as a liquidation estate of the corporate debtor, that is the gaming company. Now considering all these things, putting the GST tax on the entire amount is not correct. Okay, we have tried to say that it is not betting and gambling. Of course, the Supreme Court had said that no, it is betting and gambling only for the reasons they have quoted. Now they are trying to say that consideration, it is not my consideration. Now you are putting tax. Now how Supreme Court had analyzed it, this is going to be a very interesting point. So look here. So section 15 subsection 1 proceeds upon the value of supply. See, 15 subsection 1 proceeds upon the value of supply and not merely upon the existence of consideration. So very important point. I will just show you once 15 subsection 1 also. Here it is. The value of supply of goods or services or both shall be the transaction value. See, it is saying that the value of supply of goods or services shall be the transaction value. Now coming here, what the Supreme Court is saying that, see, the section 15 subsection 1 proceeds upon the value of supply, but not merely upon the existence of consideration. As mentioned, while consideration is ordinarily necessary for constituting supply under section 7, yes, so there should be a consideration to be called as a supply. Of course, even though there is no consideration, sometimes it can come under schedule 1 with certain limitations only. Not in all scenarios it will come. So upon the value of supply determined accordance with the statutory valuation mechanism. Here comes a very important point, that the levy under GST framework ultimately operates upon the value of supply. See what they are saying, ultimately GST framework ultimately operates on the value of supply, not on the consideration. Now value of supply, how? Value of supply determined in accordance with the statutory valuation schemes. Now we have valuation rules now. Based on that valuation rules, what the value had came that on that value GST will be applied, not on the consideration. This is what they are trying to say. I repeat, section 15 subsection 1 is proceeds upon the value of supply, not on the consideration. Now, the statutory scheme ordinarily proceeds upon the actual price paid or payable. Yes, generally it will proceed upon the actual price paid or payable. Okay, in respect of relevant supplies, except in situations specifically falling under the recognized statutory exceptions as contemplated under this act. Now, what they are saying now, first point what they have said was, see, 15 subsection 1 will go with the value of supply. Sometimes the value of supply will match with the actual consideration I am taking. But however, the legislation had a right to frame up a different scheme of valuation. Yes or no? I had that right. See, courts, whenever they are analyzing the issue, they will strictly confine to what the legislation or the delegated legislation is saying. Now, the law itself is saying, your section 15 subsection 4, section 15 subsection 5 is clearly saying, now if you refer section 15 subsection 4 and 15 subsection 5, where the value of supply of goods or services cannot be determined, or notwithstanding anything contained in subsection 1 or subsection 4, the value of supply as may be notified by the government on the recommendations of the council. So what they are saying, notwithstanding anything contained in subsection 1, 15 subsection 5 based on the recommendations made by the GST council can give a valuation mechanism. That valuation mechanism I will consider. And your 15.1 is talking about value of supply. Now that value of supply can be determined based on these rules. This is what they are trying to say. And importantly, the next paragraphs, I hope many of them may not be happy with what this paragraph had said, but anyway, the subsequent paragraphs will give more clarity. Thus, in a given case, the transaction value may coincide with the consideration. But anyway, next one, the expression transaction value in section 15 subsection 1 is also directly linked with the words which is, okay, anyway, I won't touch that point. I will confine strictly to the next wordings. The expressions in respect of, in response to, or for the inducement of occurring in section 2 clause 31, 2 clause 31 is nothing but consideration ka definition. Are of wide importance and indicated legislative intent to confer an expansive meaning, and the statutory thereof does not confine consideration only to amounts representing the final price. See, if you observe the wordings or the definition of the consideration, the amounts paid or payable in respect of, in response to, or for the inducement of, the supply. Now you think about online money gaming. So you think on behalf of, you think in the point of view of online gaming companies. See, I am an online gaming company. Me being an online gaming company, okay, I am allowing you to play this game because of that entire deposit only now. I am not allowing you to play the game only because of that. Say for example, I said that I will pay only platform fee. Will you allow me to pay the game? No. You will allow me to play the game only because of my bet what I am giving, whatever the deposit I am making. So because of that, because that deposit is inducing you for the supply of an actionable claim. So that whatever the entire deposit I am making, it is in respect of, in response to, or for the inducement. Thereby, this I can call it as a consideration, is what the Supreme Court is trying to say. And another important line, I think after reading the even below para, you will get even more clarity. In other words, since the supply itself cannot arise independent of payment of the stake amount, the same legitimately enters the valuation mechanism. See, if I am, what I have said, the same thing Supreme Court had also said, that since the supply itself cannot arise independently, see, I am not putting the bet. Will you provide me the service? So, take some person as an example. He never put any deposit amount in Rummy Circle app or Dream11 app. Will that app allow him to play the game? No, it will not allow. That is the reason. See, the deposit or the stake is inducing the gaming company to provide that service. Thereby, the deposit is legitimately coming into the valuation mechanism. In other words, thereby the deposit amount which I am making is having a rational nexus with the supply being provided by the gaming companies. Without the deposit, the gaming company will not provide me the service. Thereby, the deposit is having a rational nexus and it is legitimately coming into the valuation mechanism. There are 2 points. First point is the law had that power to draw whatever the valuation mechanism they want. So that is being supported by 15.4, 15.5. Okay. Even if I keep aside that aspect, your consideration definition is saying that whatever the amount I am paying for the inducement of that supply, that will form part of consideration. Because of the bet I am making only, you are providing the service, or you are allowing me to play that game. It means the entire deposit what I am making, it is inducing you now. It is inducing the gaming company now. Thereby this entire amount will form part of consideration now. And lastly, if I didn't put the bet, if I say that I will pay only platform fee, will you allow me to play the game? So that is the reason why the service or the supply itself cannot arise independent of payment of the stake amount. Okay. I hope I am clear here. So thereby the Supreme Court had supported their view or supported the legislative stance that why they have considered the entire deposit as a consideration. And lastly, last but one. So another important aspect was validity of Rule 31A. The petitioners had also challenged the validity of Rule 31A. So what they have said was Rule 31A is ultra vires of section 15 subsection 1 as it artificially enlarges the levy beyond the actual consideration. And see, they are trying to say that no, 15.1 is, of course, this issue had already, by this time, we had already discussed this issue and it doesn't have any, it doesn't require any more explanation. So what they are saying is it artificially enlarges the levy beyond the actual consideration. It means that transaction value should be the value of supply. So you are going beyond and you are saying that the entire deposit is an consideration. But just now we have discussed that why deposit can be called as a consideration. And also the other thing was 15.1 mandates valuation based on transaction value and 15.5 only permits prescription of valuation rules for notified supplies and cannot authorize a valuation mechanism disconnected from the essential characters. And Rule 31A3 was prescribed without notification. So the new point which I think I can discuss here was this one. Rule 31A3 was prescribed without any notification and 31B and C was brought through notification number 49/2023. So look here. See, already there was an extract of 15.4, 15.5. I will quickly summarize the petitioner view here. Now, what the petitioner had tried to submit was $15.5 what they have said was, notwithstanding anything contained in subsection 1 or subsection 4, the value of such supplies as may be notified by the government on the recommendations of the council shall be determined in such manner as may be prescribed. See, to bring a delegated legislation that is a rule, there should be a power given in the law. Now what they have said was the Rule 31A can be brought either through section 15 subsection 4, either through section 15 subsection 5 or through a general lawmaking power section 164. Now the contentions of the petitioners was, see, if you start considering that the Rule 31A was brought through 15 subsection 4, in 15 subsection 4 it was said that where the value of supply of goods or services cannot be determined under subsection 1. If it is not possible to determine, then only you have to issue a notification under 15.4. Here that is not the scenario is what the contention of the petitioner. And also they have said that even if you are assuming that the Rule 31A was brought through 15.5, to brought some rule under 15.5, there should be a separate notification should be issued. So what the petitioner had submitted was Rule 31A was not brought through a separate notification. it was brought in a general notification, general lawmaking power ka 164. By using 164, they have issued some notification. In that notification, it had came. It didn't came through a separate notification. Is one of the contention of the petitioner. These are the contentions made by the petitioners. Okay, stating that Rule 31A is invalid. Now, what Supreme Court had said was, on a conjoint reading of 15.4, 15.5 and 15.16 subsection 4 and section 2 clause 87 reveals a common statutory threat, namely the requirements of recommendations of the GST Council. Now, what Supreme Court had said was, see, okay, you whatever the points you have said, I have considered, but in all these three sections, what is common was it should be prescribed, or it should be, see, the word prescribed also they have said. Prescribed means rules made under this act on the recommendations of the GST Council. Now, what the Supreme Court had said was, in 15 subsection 4, 15 subsection 5, section 16, 164, what is common was a recommendation of the GST Council is common. Now, the moment recommendation of GST Council is there, why you are worrying? Okay, as the valuation mechanism of Rule 31A was recommended by the GST Council, it doesn't matter. You cannot say that Rule 31A is invalid. Okay, so this is what the discussion happened with regard to Rule 31A. And also what the Supreme Court had said was, Rule 31A cannot trace its powers in section 15 subsection 4 is what one of the petitioner had said. That the expression, why? Because whenever the valuation cannot be determined, then only you have to go with 15.4 is what they have said. But what the Supreme Court had said was, the expression cannot be determined, cannot be constructed in a narrow or pedantic manner, okay, or it will not apply only in absolutely impossible cases. What Supreme Court had said was, see, sometimes there can be differences of opinions or differences of practice can happen in the industry, or there can be a confusion. That also you can consider as cannot be determined. Cannot be determined need not to be impossibility. Cannot be determined means there can be a confusion in the industry, or industry is seeking clarification. It can be anything. Thereby, even if you assume that the Rule 31A came through 15.4, it is proper. Okay, so I hope I am clear up to here. So the next one, or the last one of this case discussion was, see, up to here, okay, I tried to say that, I means gaming companies, I tried to say that it is not, it is a betting and gambling. Okay, you rejected. And I tried to say that no, my consideration is not that. That also you have rejected. And I also tried to put before that Rule 31A is unconstitutional, or it is ultra vires. That also you have rejected. Now, my point was, see, the rules 31B and 31C was brought with then prospective effect, with effect from the notification. The wordings itself was with effect from, but your department or revenue is arguing that it is having a retrospective effect. So this was analyzed now before the Supreme Court. So I can say that of course I mean to say that I couldn't understand, or I couldn't appreciate. I don't know whether this is a proper wording to put or not. Maybe I would say that I couldn't understand the logic of the Supreme Court, or I am not equipped enough to understand the logic behind that, saying that the rules were retrospective. See, they have simply said that already everything was explicitly there in the Rule 31A. What was already there, what was already implicitly there, that we have made explicit with this amendment. We didn't enlarge, or we didn't created, sorry, not we, the legislation didn't created any new leg or new scope, or it didn't enlarge the original provisions. It just clarified what was existing earlier. Thereby, this can be considered as retrospective effect, is what Supreme Court had said. Now, the Supreme Court had even said that just because it is mentioned there that with effect, it doesn't mean it will be prospective only. It can be retrospective also. In this scenario, it is retrospective because already it was existing, that was clarified to clear the confusion of the industry is what they have said. But however, there are some points based on which we can say that this should not be retrospective, it should be only prospective. Now what are that? See, to be called as a retrospective, what was implicitly existing, that should become explicitly. And also generally whenever any retrospective things and all had happened, generally it will what happened was Supreme Court had relied. I just want to go back to the Supreme Court analysis on this aspect. Supreme Court, to say this, had relied on many judgments. In all these judgments, what was common was there was only one amendment happened. There was only one amendment happened, and that one amendment they have said as retrospective effect for various reasons. But here that was not the scenario. There were rules introduced. There was an schedule being there was a change in the schedule, there was a change in the act. So thereby excuse me, thereby the Supreme Court should not say this as an prospective, should be retrospective. And also the very more general principle or the last principle was, in general, delegated legislations cannot be retrospective unless supported by an amendment in the act. Here Rule 31B or Rule 31C, whatever I have introduced, that was a second delegated legislation. I cannot call it as retrospective unless supported by the act. For these reasons, in my humble opinion, the amendments or the rules introduced should be considered as prospective only, but not retrospective. So that's it, friends, from my side. If you really like this deliberation, or like the what the better word I can put was the sharing of my understanding, I can say that this is sharing of my understanding of this Gameskraft. If you really like this, please like, share this video to your friends, and also give your valuable feedback through comments. And before ending, I would like to thank Arvind P. Dattar sir, learned senior advocate of Honorable Supreme Court, who was the learned counsel for the petitioners in this case. The majority of this content and majority of this understanding was done by watching his videos, and also after putting some efforts of reading this judgment. But I would really acknowledge him because of his video and because of his explanation, deliberation. I've got some clarity which I have made some other research and I have tried to put before you all. So I really would like to thank Arvind P. Dattar sir. Thank you everyone. Thank you for watching. Namah Parvati Pataye, Har Har Mahadeva Shambho Shankara. Thank you. Jai Hind.